Tēnā koutou katoa, ka nui te mihi ki a koutou katoa. Tēnā koutou, tēnā koutou, tēnā tātou katoa. Thanks very much for having me at this great conference. I'm a very keen proponent of plain language, and perhaps there's something of a parlour game. You can see how many times I breach some of the 10 commandments in this speech, but I'll try not to. Easily said, sometimes harder to do. But as Honor said earlier, that plain language is a justice thing, and I couldn't agree more. And I want to talk a bit about why I think that plain language and enhancing the rule of law in our democracy go hand in hand. The rule of law, as many of you will know, is at its core the concept that everyone, including the state, or the Crown if you like, and all of its actors, are bound by and entitled to the benefit of laws that are openly made, publicly available, and transparently enforced in our courts. And our democratic system of government gains its legitimacy from this rule of law. We live in a democracy committed to the rule of law. And as Solicitor General, I think I can play an important part in that, along with the Attorney General and the Solicitor General, and we're quaintly known as the senior and junior law officers, as if that means anything to anyone. We are charged with ensuring government is conducted according to law. And that's both a real privilege for me and something of a burden I appreciate that I hold, and I hope I will always feel like that about my role, because the rule of law, the integrity of our institutions, the long-term interests and obligations of the Crown, and democratic government according to law are all really important values to me. But one of the central characteristics to the rule of law is that the law must be accessible to the people. And the great lawyer and judge Lord Bingham famously said, as one of the elements of the rule of law, it is that the law must be accessible and, so far as possible, clear, intelligible and practicable. But the challenge for accessibility to the law is not just to make sure, literally, that people can access our courts or tribunals. And that's another conference, all the complexities about how justice systems can be made inaccessible through fees and cost of lawyers and so on. But I say the rule of law requires something much more basic in our quest for accessibility. And it's this: if we are really going to claim commitment to the rule of law, we must also be committed to making sure that the system that governs us, the checks and balances that are in place, the constitutional framework that we live in, being clear, open and well understood by everyone, not just some people that live in Wellington, which is sometimes how it seems. Without a good understanding of those frameworks about how the branches of government operate, the independence and the dependencies between those branches of government, without clearly understanding that, citizens can develop a cynicism about our democratic institutions, and that really tells against accessibility of the law. And I don't think we're doing very well in New Zealand. Reading the news, working in the public sector, I think there are some really basic misunderstandings about the constitutional frameworks that we operate under. Does it matter? I think it does. Because for accessibility to be meaningful, people need to trust the institutions that deliver the law and operate according to law, whether it's government making decisions or agencies enforcing the law or judicial officers in courts and tribunals up and down the country dispensing justice. Unless our people trust those institutions and don't cynically view them as a corrupt and meaningless architecture of a powerful state, accessibility to the law will lack real meaning. And language is a really powerful way to make the law accessible. Language can include or exclude. It can advance or hold back progress. And as this conference clearly evidences, for far too long, lawyers have revelled in complex, hard to understand, mired and technical, difficult language of the past. I've always been a bit inclined to plain language, but for a long time it made me think that it meant that I wasn't very smart, because I had the clear evidence in front of me that many lawyers were obviously smarter than me because I could never understand them. But the first time I realised that actually complex legal language wasn't a virtue was a while ago now. I was a young lawyer and therefore I hadn't been invited to a really crucial meeting with a minister who was giving instructions to the department about what we were to do next. The senior lawyer in our team attended. She returned to the office, she delivered the instruction, and she went on leave on an overseas holiday. When I appeared the next day to catch up on what the minister had wanted, no one knew what to do. And I was saying, didn't Mary, that wasn't her name, didn't Mary tell you what the minister said? Yes, they said she came in and told us, but we were all too scared to say that none of us understood what she had said. Mercifully, plain language is gaining prevalence, finally, although I agree with the judge, there is plenty of improvement to be made yet. New Zealand's plain language movement in law is probably best seen in our modern statutes. The modern New Zealand law is being carefully crafted by our expert parliamentary council, many of whom are here today. So you will now see evidence of the 10 Commandments being reflected there, diagrams, examples, plenty of headings, many other signposts to help you get through the text. You will see expressions such as notwithstanding, and sometimes, subject to, being replaced with more straightforward active voice phrases. For example, this section applies despite anything in section X. Stuff you can understand. We should see less Latin, we should see more words that we all understand. And the Legislation Act also allows revision of acts already made to update them for better accessibility. So a bill can be enacted that does a few things, like changes language, turns it into gender-neutral language, changes expressions to more modern, well-understood expressions, and so on. Revision bills can include examples, diagrams, flowcharts, readers' notes, all about aiding accessibility and readability. So I've already mentioned many of my colleagues are here. They are the experts in plain language drafting. You should talk to them, because I actually want to spend the rest of my time really furthering His Honour's challenge to the profession that we must embrace plain language in order to advise well, to persuade courts and decision makers to see our point of view, and frankly, to remain relevant as a profession. The language of law is to persuade, to advise, and in the case of judging, to determine disputes between parties so that justice is done and that justice is seen to be done. And I tell my colleagues in Crown Law, and any other colleagues if they will listen to me, if our clients can't understand what we're telling them, if they need a lawyer to translate what our advice means, then we're not doing our jobs right. And at law school, at least in my experience, for many years since, people expect the product of what lawyers deliver to be a legal opinion. We've all got this idea of what a legal opinion looks like. There are many books and in offices all around the country, precedents for what a legal opinion looks like. Many of those precedents will now urge plain language. When we're asked for an opinion, we diligently prepare one and we give it to our clients. And I'm frequently struck by the unnecessary stuffing that an opinion will contain. So I've started challenging my colleagues to think hard about this. What is the product that we lawyers should deliver? In my context, our advice is usually for ministers and other busy decision makers who need a hand with how to decide lawfully how to implement their policy choices. So do we really want to deliver them a decision maker like that, a 15-page or worse, highly polished product that is a legal opinion? It might be replete with Latin phrases and quotations from case law. If we think about the purpose of our function being to advise, to help the decision maker to act lawfully, or perhaps to understand the risk they face, that is what we are to do, to help them. It's not to prove how much we know. It's not to show how complex the question is that is being asked. My challenge to my colleagues is to start thinking about something different from the classic legal opinion. Could we produce a flowchart? Could we use a page of bullet points? Can we use a diagram as the product that we deliver? Why not? Actually, when I've been doing this lately, I've realised I also need to educate the receivers of legal advice. They also expect something quite particular. They understand that we turn the clock on, that every 6 minutes ticks past with various cost, and getting a page of bullet points might seem like something of a rip-off. I did recently send a one-page set of propositions as bullet points to a decision maker so that when we met later in the week we could go through the propositions. He was quite alarmed. He rang me to say, I think I need more analysis than that. So I did have to convince him that I hadn't just made it up, like I hadn't just started with the bullet points. I said I can give you the 25-page research opinion and I can give you the 5-page summary opinion if you want. So I think he did want those because I think also he felt a bit anxious that I had just made it up. So I'm not advocating that at all. I'm certainly not advocating to my lawyer colleagues that we should just start making stuff up. We need to do the analysis. And we need to know the principle, we need to know the case law, we need to understand the complexities of what's going on. But do we need to tell you? Do we really need to tell our client all of that when actually often what they want to know is, what do I do next? One thing plain language advising does is make our profession much more open for others to engage in, perhaps to challenge where we get to about this is what you need to do next. And as we move more and more into a technologically enabled world, non-lawyers can access the words of the law, as enacted by Parliament, themselves. And then if we're speaking in plain language, they can determine for themselves, perhaps, if they agree that that's the way the law should be applied to their facts. And actually now we see the rise of artificial intelligence to help draft legally sound documents or to work out what the law is that applies to your facts. The New Zealand Law Society newsletter recently pointed out that a US law firm has hired a robot called Ross, an IBM product. The firm's lawyers can ask Ross a research question in just an ordinary English language. They don't have to know code, computer code. For example, can a bankrupt company continue to conduct business? They'll receive an instant answer with citations and topical readings from legislation, case law and secondary sources. And Ross keeps working on that question, even when you've gone home to bed, providing updates on any relevant changes in the law. And all of this might seem a bit alarming. Isn't there a risk to diluting something of our profession's mystique and special character that we like and that we charge so well for? But trying to cling to that, I think, is a professional arrogance that I don't approve of. So I think we do better to open the door rather than to try and keep it shut. But I don't think it's time to kill all the lawyers just yet. As long as we adapt and remain relevant, there will continue to be a need for lawyers who can communicate clearly and plainly. Use of technology should be something that we grasp onto to advance and give an edge to our profession. And I don't underestimate the challenge we are facing and all posing at this conference. Analysing the law and how it applies requires precision and a lack of ambiguity. And we've spent a lot of time learning our legal discipline. But to my way of thinking, the really smart lawyers are those who can digest that complexity, apply it and explain it in a plain way. There are a few tricks to learn, like is honour, I think there are only a few, to make a very big difference. If we write for the ordinary intelligent reader, we will be more persuasive. Storytelling is a really good example. We will have fewer errors of logic and our writing will be easier to digest. I think we'll be more persuasive too if we can take the reader, whether it be a client or a judge, through a well-reasoned, easy-flowing narrative. I was interested in His Honour's 10 Commandments. I won't go through some of my ideas because happily they are in his 10 Commandments. Use simple words even when you know big ones is one of my rules. Don't use stuffing. Bridges and signposts. Avoid Latin. Perhaps that could be another commandment. And I was interested in the question that came about the time it takes to turn something into plain language. And I think it's attributed to Mark Twain, the excuse, I'm sorry this letter is so long, I didn't have time to write a shorter one. And it's a common excuse with opinions and submissions too. But like chicken stock, legal writing is vastly improved by putting all the elements in to start with and then reducing it to its essence. So to that questioner who said, how do you do it? You have this thing and you have to rewrite it. I took it that you hadn't written the first thing, but if you start with the discipline of plain language, and even if you jot down your complex analysis, don't polish that. Just bung it down in an outline or a series of bullet points, and we can do this so well now, what with using computers, move stuff around until it starts to make sense. Then when you polish it, you won't be double handling it. You'll be spending your polishing time with a product that you're already moving into plain language. And of course, I also urge plain language on judges, respectfully, of course, always. And there are some recent examples of the discipline from judges, and they are a good lesson to all of us. And I don't have a Justice Kirby judgment to use as my example, but I do have an example, one from the Ontario Court of Justice and one from the Liverpool courts. In the Queen and Armitage, the court was writing in respect of an Aboriginal offender, and there is a principle of Canadian law that when you're sentencing an Aboriginal person, the sentencing court must take account of all reasonable alternatives to imprisonment. So the judge says, before I get to the decision, I want to make two short comments. First of all, I want to say something about the style of this decision. For those who've read some of my past judgments, you will notice a change. For Jesse Armitage, I have tried to say what I wanted to say in very plain language. I believe this is a very important thing for judges to do in every decision, but judges often don't do a good job of this, and I would describe myself as one of the worst sinners. As lawyers first and then judges, we get used to using words that are long and complicated. This only muddies the message we're trying to say. That message is very important when it comes to sentencing an offender, especially so in this context that he refers to of the Aboriginal Sentencing Court. When judges write their decisions, they are writing for different readers, for different audiences. They write not only for the parties before them, they write for other readers of the law, they write for lawyers, they write for other judges in the community. In this case, I'm writing for Jessie Armitage. So too in the Liverpool Family Court, a very plainly worded judgment was delivered in respect of a custody battle in relation to 4 children. They were then aged 12, 10, 3 and 10 months old. The judgment starts, this judgment is as short as possible so that the mother and the older children can follow it. And it goes through very simply and with real passion and humanity, explaining to the children who, if they can read it or when they can read it, children can't be taken away from their parents unless social services prove to a judge that it would be harmful for them to live at home. People can sometimes tell lies about things and tell the truth about other things. And children are not taken away because their parents are rude or difficult or because they have strange views. The only reason to take children away is because they need protection from harm. Excuse me. And so on it goes in a really simple and straightforward narrative to describe the children's custodial arrangements and then to decide them. And in both those cases, I'm sure the judgment writing took considerably longer than it would have been if the judge had only been thinking about the lawyers and leaving the translating to the lawyers for their clients. But I really hope we don't end up returning to the approach of the Chancery Court in England. In a case Mylard and Weldon, Mr Mylard filed a 120-page document to present his case to the court, his initial pleading. And the judge thought 16 pages would have been enough. So for that heinous crime, Mr Mylard was imprisoned and fined £10. And if that wasn't enough of a punishment, he then ordered a hole be cut in the offending document, that Mr Mylard's head be poked through the hole, and that he be paraded around the Court of Westminster bareheaded and barefaced, with the document hanging written side outward. He was sent back to prison until he paid the £10 fine. That was how the 16th century court dealt with non-plain language and too long a document. I don't think that same approach would be tolerated today, but I like the spirit of it all the same. The Supreme Court of Ireland judge, or he was then the Supreme Court Judge of Ireland, Mr Justice Nicholas Cairns, wrote an article in the Irish Times a while ago on his thoughts on judgment writing, and he was advocating the use of language and ideas that people could understand. He said, "When writing a judgment, I see no reason why references to current events or popular culture should be seen as taboo." And he pointed to a US survey which had been conducted to find out which popular culture artists are most frequently cited in the courts. Bob Dylan was the winner. Apparently, you don't need a weatherman to know which way the wind blows to work out when expert evidence is required in appellate court decisions. But anyway, he went on to say, the primary functions of a judgment are threefold. In the first instance, it provides a resolution to the dispute raised in proceedings before the court, where the focus of the losing party is for the judge, where the losing party is the judge a primary focus. The judgment must set out clearly reasoned basis for its conclusion. Secondly, the judgment establishes a binding precedent of legal authority. Thirdly, and this is the point that I want to emphasise, it also serves as a communicative function which should be of benefit to society as a whole, representing as it does the transparent and openly democratic functioning of our legal system. And it's that third element which shouldn't be forgotten, and to me seems like an essential element of accessibility. The law of the judges is the common law, as distinct from statute law, which is the laws passed by Parliament. So right, New Zealand laws are made up of both statute law and common law. So the judges are making up the laws of the country. And as this quote shows, there are three things being done: determining the dispute, developing the common law, and showing clearly to the citizen how the legal system works, what the law is, and why it matters. My ambition is that we move society to a point where people do know about the constitutional framework and the laws that we are all governed by, so that people know how they are affected by the law, what their rights are, how they can hold governments to account, how they can hold others to account. Using plain language and letting people into this once closed shop of lawyering is a powerful way to achieve this ambition. A society with an empowered citizenry will demand access to justice. not just to the statute book, but to the content of the common law and to our justice institutions. And that's a society I'm very keen on being part of building. Tēnā koutou, tēnā koutou, tēnā tātou katoa. Sure. It is officially now your morning tea time, but if anybody would like to rashly ask questions instead and stand in front of everybody else's cup of tea, please go ahead. I'm going to stay around for the morning tea, so I'm also happy to talk to anyone at that event. Yeah. Yeah, you do.
So as you, when I grow up, so as you, sorry, my name's Jenny Vickers. I'm ex-Chapman Tripp and now work for the International Association for Contract and Commercial Management, which is a group of people around the world who are passionate about making contracts work better. And I'm curious to know whether you're seeing more openness within big law or little law of the law firms to starting to make the change.
I think in the written opinion work, yes, certainly, I think you probably couldn't find big or little law firms that say don't say you must use plain language, but there is so much more of that, contract drafting and some of those things that still are. I mean, I know you've got sessions on this coming up, but they're still so mired in the language that we think we know, or maybe that we do know what it means, that it's very hard to take our hands off that wheel. But I do see a huge advance in the way people write legal opinions. They are becoming a lot plainer. Legal submissions, not so sure. I think that still is something of a closed shop where I'm the lawyer, I'm talking to the judge, the lawyer, and I can talk in this funny way of expression. But I don't think it does I don't think it's a good persuasion tool. I think that's one area where I'd like to see a big shift.
Can I ask a second one? So linked to that, are you seeing more willingness by the legal profession to actually get better at understanding whether if it's a commercial contract, that the commercial piece that sits underneath it, and for such a long time we give commercial legal advice has been a nice thing on a website but meant nothing in most cases. Are you seeing some more willingness to get stuck into the businesses, the organisations, to better understand what actually matters?
Maybe. I think I'm still seeing a real proprietorial approach to the law, that it's ours and we want to keep guarding that. And I think that's the real challenge, is that when we really unleash plain language and communication, we won't be able to keep that position anymore. So I still do see that expertise and proprietorial approach to the law.
Yeah. Thank you.
Thanks, Jenny. Very good. Sounds like a cup of tea time.